Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago as usual. And it was a rough day for clips, but I found them. I found them because I'm a professional. I am a YouTube professional. I had to go all across the country. I discovered the country, but we've got Michigan, we've got Kansas, we've got Washington, we've got, what else do we have? I don't know. Texas? Something like that? We got some good stuff. But the first one, of course, I got from Discord. Mikhail hooked me up again. We've got Judge McNally. We're going to kick it off with a little bit where a guy tries to make a Cheech and Chong joke to Judge McNally, and he's either not having it or too busy to acknowledge it, and that's even funnier. So let's get it started, shall we?
Cheech and Chong would say that's some powerful stuff, Your Honor. I have no idea what it was. It's the first time I used them as a defense in my career, Your Honor.
So here's what happened, just so you know. I'm told the defense lawyer isn't here. Apparently, on February 15th, as I recall it, all of a sudden the defendant appeared on Zoom, and it turns out he'd been violated at Elmhurst for smoking. And I set a court date. We had this court date set February 21 at 8:30, and I said try to get a hold of the defense lawyer.
Okay, so her opposing counsel isn't there, and he is so cranky about it. It's not that funny. It's just he goes on. He's absolutely right, by the way. I agree with him. But I just like how he's so indignant about it. It's fantastic.
The defense lawyer showed up on February 15th or 16th. I can't remember. I wrote 15th. It seems like it was the next day. But the defendant was not on Zoom. I said to keep the court date for February 21 at 8:30. Lisa, have you heard from the defense?
Good Lord, this little prosecutor, she looks as young as Caitlin Kirby over there. You just have to bear in mind that she's got nothing to do with it. Her only sin is that she showed up to court like she's supposed to.
Defense lawyer?
I did. I spoke with her last week and trying to locate her client. And then I received notice from my OIC that he was back incarcerated, but I haven't heard anything other than that.
Do we know why she wasn't here today, the lawyer?
I do not.
Send a letter I want a letter going to assigned counsel from you, Lisa, or Amy, telling them that the defense lawyer didn't show up. I don't know what else to do at this point. We're still awaiting a competency exam. I'll just make a note. Defense attorney failed to appear. Defendant not put on Zoom. But I do want a letter going to assigned services counsel telling them that this lawyer did not show up today. I don't understand. Counsel, how long you been practicing, Ms. Kelly?
About 3 years.
Don't ever get in the habit that some of these are in, okay? Please don't ever do that to this profession. I don't understand it anymore.
I will try my best.
I know. I hope I'm sure you won't, but some of them I just don't get. I'm not sure why this happens. I just don't. And believe me, I'm not the only judge in the county that feels this way. It's just this generational lawyer. I don't get it. I'll show up when I feel like it. I sometimes think it should say big boy out in front of our place because I guess people don't think it's anything other than a restaurant.
Thanks for the timely big boy reference. I mean, it's a restaurant. I've eaten at it, but I haven't seen one in 20 years. I don't think it exists anymore. but okay, Judge. He's just too fun. All right, here we go. Milo just told me to tell you to hit like and subscribe, and she's serious.
Hey, Judge, how you doing?
Well, I'm all right. Thank you for asking. Are you Darren Bobo?
Yes, I am, ma'am.
And that's Darren with an E?
Okay, so this is out in Kansas. We've got our prosecutor, and we've got a judge that I don't think I've had on before. I've seen her before, but I don't think I've streamed it before. Judge Satterfield. I don't. This guy's just a hoot. This defendant just can't shut up, and it's the usual thing, but it's funny.
Yeah, DARREN. Same.
2 R's?
Yeah, 2 R's.
Okay,
Correct.
thank you. The county attorney's office has charged you with the following charges in Butler County District Court case number 2023 CR 87. In count 1, you're charged with assault on a law enforcement officer. It's alleged that on or about the 17th day of February 2023 in Butler County, Kansas, that you did knowingly place a uniform and identified officer in reasonable apprehension of immediate bodily harm while the officer was engaged in the performance of his or her duties. It's not alleged that you did this with a weapon or a vehicle. Therefore, it is a Class A misdemeanor. The difference between a misdemeanor and a felony generally is if you're convicted of a felony, you run the risk of going to prison. If you're convicted of a misdemeanor, jail time is the only incarceration that you can receive. However, an A misdemeanor carries a maximum sentence of 1 year in the county jail and a $2,500 fine. There are no mandatory minimums. Count 2, you're also charged with a Class A person misdemeanor. It's alleged that you bit Deputy Bruce.
I did not.
Okay, I'm just saying these are the allegations. I'm going to enter a not guilty plea for you, and I'm not asking you to agree with them. I just have to.
Okay, so far he's shut it out twice, but both times it's I'm not guilty. You're much better off just shutting your hole. But if you are going to say something at this hearing, saying I didn't do it is probably the best thing to say. Not nearly as good as quiet, but it's the best thing to say. However, it gets worse.
Advise you of what the charges are, and if you were convicted, what the potential maximum penalties could be. Okay? So it's alleged on that same date that you caused physical contact and bodily harm to Deputy Bruce. That carries a maximum, that's known as a battery against law enforcement, maximum 1 year, $2,500 fine. Count 3, you're charged on or about the 17th day of February 2023 in Butler County, Kansas, in obstructing, resisting, or opposing an officer who is engaged in the discharge of an official duty. That's what's referred to as interference with law enforcement. That is also a Class A. However, it's a non-person misdemeanor. The other two, count 1 and 2, are person misdemeanors. The importance of that is when criminal history is calculated for future purposes. If you have person misdemeanors, 3-person misdemeanors equates to 1-person felony. It moves you up the grid as far as sentencing guidelines are concerned, but that's only something to worry about in the future and if you were convicted. But that's why I'm distinguishing for you what's a person versus a non-person misdemeanor. In count 4, you're charged with biting one deputy marshal. This is also charged as a battery, Class A person misdemeanor, 1 year, $2,500 fine. And then lastly, count 5, you're charged with a misdemeanor theft of a backpack that was alleged to have been owned by a Nathan Whitehead, and that Nathan did not give you permission to take the.
Yes, biting and backpack theft. I can't explain it to the rest of the world, but I knew it was right for this channel.
The backpack, but the backpack and its contents were identified as less than $1,500 in value, making it a misdemeanor as well. That is a non-person misdemeanor.
If you know, you know.
Maximum 1 year, $2,500 fine. I'm going to enter not guilty pleas for you. Mr. Bobo, what is your work history? What's your current work situation?
To be honest, I'm working, and I got a daughter, and I'm really, really, really struggling right now. And my mother got cancer. My baby mama works. She's in Oklahoma taking care of taking care of my mother with my daughter. She has stage 3 thyroid cancer, and my grandma's getting sick. She's getting old, and I really,
By the way, my baby mama in Oklahoma is my next single.
to be honest with you, it's just a lot of things going on. But I mean, it ain't nothing that's too much for them not to. They can handle it without me. To be honest with you, I mean, anybody, they're grown people. They can handle it without me.
Okay. Well, how much do you make a month?
To be honest with you, it just depends. It just depends on how what I work. To be honest with you, a month, probably like 2,500. It's not that much. Well, not even that. Like 2,000.
And you have one dependent?
Yeah.
Do you have a house that you own or a car that you own outright or savings?
Right now, I'm still staying with my grandmother.
All right. Well, to get this case moving, I'm going to appoint Darren Patterson to represent you. What happens is
this poor guy. I got to get Darren Patterson on the show. I think he's been on. He gets everybody. He gets everybody from all the judges, Judge Hart, Judge Webster. Everybody sends him to Darren Patterson. It's not a good group.
there's a standard fee. The county pays him a salary. He represents folks who don't have the money for attorneys on misdemeanor cases. He's a well-seasoned attorney. But if you are convicted of any or all of the charges, there's at least a payback fee of $250 for his services. So it's free on the front end, but there may have to be payment on the back end. All right, so now I need to look at setting bond for you. Where do you live?
In Belle Plaine, Kansas. I do not have no holds. I've been out of trouble. It was really a misunderstanding, to be honest with you. I was trying to get him off me, and I accidentally did some stupid stuff, and I understand. I take full responsibility for everything that I did.
It was a misunderstanding. No, it wasn't. You got charged with a crime. And then here's the thing. She just appointed you an attorney. Don't start saying things like I did stupid stuff. Believe me, we all know you did stupid stuff. Just don't say it. And if you think this prosecutor is going to give you a break or forget it, he's already got it in his little database. Okay, stop talking.
Okay, don't say too much about the incident itself. So you're not currently on parole or probation?
I'm on parole, but it ain't no felony, so it's not no parole violation. But what it is, I'm taking.
See, Judge, here's how the law works. I'm on parole, but it's not a felony, so it's not a violation. Okay.
Responsibility for all of these because I'm a man, and I really, really, really have to get home to my people. So if there's any try to get like probation and just pay, I'll pay a lot of money. And I need to take care of my mother. I need to work. I got a daughter. I got to take care of my grandma. I got to do a lot of things.
I got an idea. Maybe about the time you started biting a cop, you should have thought about this.
Well, right now I'm just going to set a bond amount for you. What is the recommendation from the state?
Your Honor, $5,000 professional surety. This particular case does have some rather interesting facts. Pursuant to the affidavit, paragraphs 5 and 7 through 9, this case appears to involve a stolen vehicle out of the Wichita city limits, but the defendant was apprehended in Towanda. Additionally, it appears the defendant threatened to kill the arresting officer before attempting to flee on foot. Then he fought both the arresting officer and the second officer, biting one twice while attempting to gouge out the left eyeball and take the service weapon from the other. Also, it would appear that pursuant to paragraph 11 of the affidavit, the defendant admitted he stole the vehicle. Additionally, insofar as the prior allegation from the defendant regarding any additional holds, it would appear that there is another active hold for this particular defendant from the Kansas Department of Corrections.
Okay, so the prosecutor is on top of it. We know he's a tough kid, but to his credit, he is all over this thing. I think he handles it well, and it is the wrong guy to be playing loose in front of. It really is.
I know that I'm not taking responsibility for that. I'm talking about this for these little 5 misdemeanors.
Okay.
Oh, he's taking responsibility for other things, not this. So he's got. Y'all understand, right? He's taking responsibility for some things, not others. All right. Okay.
All right. I'm gonna set your bond at 2,500 cash or surety with GPS required.
No one asked.
All right, you have an attorney.
Have a
You have
hold.
a bond. Now I need
Where's
to
my-
give you a court date. It's April the 24th at 8 a.m.
I need to speak with a detective, to be honest with you, because it was I've already explained about all the vehicle stuff, but
What are those forms? It's been a while. Form 9s up there at the jail.
Yeah.
What are those forms that inmates can fill out
I'm
to
answering.
ask that a sheriff's
Sorry.
officer talk to him or something?
I'm
Does
answering
anybody jail-
For these 5 charges, these battery charges, I'm entering the guilty plea, but for the rest, I'm entering the not guilty plea, because for the simple fact that I have.
Yeah, you probably are. Now shut your mouth. When you have your attorney, you can probably work a deal and you'll plead and get some charges reduced. That's how the game is played. Stop freaking talking.
Proof and substantial evidence that it's all on camera, that I was set up, I was forced, I had to walk, the car
Okay.
got stolen.
Okay, don't say any more.
He was forced to steal a car and bite a police officer. I don't know if he's trying to set up I don't know where he's going.
About your case because this is being recorded. I want you to talk to your attorney in confidence. Okay. I'm not going to enter. These are serious charges. You may have some parole ramifications. I'm going to enter a not guilty plea on all of the charges.
And I think he's setting up an entrapment with a backpack because it was a sexy backpack.
Set your case for court April 24th at 8. I've set a bond and I've given you an attorney. If you want to speak to a detective, I think there's a form 9 or some form you can fill out to make that request. Okay.
And I never.
All right. Thank you.
Hey, do I have a hold, ma'am?
I have no idea. They'll have to run. You can also fill out a form 9, ask that they run you to see if you have any kind of holds. And if you talk to a bondsman, they'll double check that for you too.
The G Razor, would you mind if I asked, did you say that I have a hold from another county?
Oh yeah. He just asked his prosecutor for a favor. I mean, look at this guy. Look at his haircut. We've given him a hard time, although I think he's doing a great job here. I will say that. But literally, if you're reading the room, do you think that guy's going to help you? Just ask yourself that question before you open your mouth. Okay.
He thinks you do, but that has to be ran through the sheriff's office for confirmation.
Stupid
Okay, I
sex.
appreciate
And they're the ones that are the repository for any kind of holds. He thinks you do.
Okay, I appreciate it.
All right.
Okay.
Your Honor,
Yes.
in addition to the, given that the court has set bond at 2,500 cash or surety, while I do acknowledge that the court has ordered GPS monitoring in this case, the state would further request as an additional special condition of bond that the defendant shall have no contact with the victims or any endorsed witnesses.
Yes, that's standard on all bond forms, and that will be ordered.
Thank you, Your Honor.
Thank you.
This is case number 23-1-211-08.
Okay, this is not. It's short, but this is what inspired it. It was the best of haircuts. It was the worst of haircuts. You got to see these back to back. But this woman is in some trouble. But it's the opposite scenario. She's got a competent attorney, and she has the good sense to shut her trap, and things go well for her.
They reviewed a probable cause statement prior to court, and they made a finding of probable cause for possession of a stolen vehicle, as well as driving license suspended in the 3rd degree. You have a right to remain silent about the charges in the case. You also have a right to an attorney. Do you wish to have an attorney, ma'am?
Yes.
I kind of like the hair.
Right. I believe that is Mr. Goodday, who would be appointed to represent you.
For incarceration,
Ms.
I'm
Knowles,
impressed.
state's position on release.
In Washington, she has 3 misdemeanor convictions with pending theft 3 and a DUI, 1 felony conviction, 5 warrants, 1 of those being active. We would defer the court on the issue of bail. We would just ask that if she's released, she have conditions of release to include reporting to offender services based on her warrant history, 1 of those being active at the time of arrest.
Thank you, Your Honor. We would not object to reporting to offender
Yeah.
services. We would ask that she be released on her personal cognizance. She did indicate she would appear for all future court hearings. The latest warrant, she indicated she was snowed in and she tried to get in contact to get that warrant quashed, but was unsuccessful. So we are asking that she be released on her personal cognizance.
All right, Ms. Covington, if you're released on your promise to appear, can you assure me you'll show up for your court hearings?
Yes, Your Honor.
All right.
I mean, that's all it took. Her attorney is good. She's a public defender, but she's doing a nice job with it. And she says that to the judge, and the judge said, "Okay, well, do you promise to come back to court?" She's like, "Yeah, okay, all right, we'll let you go."
Excuse me. I'll authorize the release on a promise to appear with a couple of conditions. One is you attend all your court hearings, also report to offender services on their schedule. You'll receive some paperwork on how to contact them once you're released. They're across the street at the Hall of Justice on the 3rd floor. I'm also going to sign an order requiring you to meet with your attorney prior to your next hearing.
Next, we'd like to call number 16, Mr. Frank Martinez.
All right, here, you tell me which is the good hairdo, which is the bad hairdo.
All right, good afternoon, sir. You are Frank Allen Martinez, Jr.?
Yes, sir.
All right. Sir, I reviewed a probable cause statement prior to court. Based on that, I made a finding of probable cause for 2 charges. One is assault in the 2nd degree, and 1 is indecent liberties. You have a right to remain silent about.
By the way, I had to look it up. He's charged with assault and indecent liberties. I looked up the Washington Code. It says exactly what I think it says. The offense of indecent liberties occurs when someone takes S liberties or has unwanted S contact with another person, which is exactly what you would think. But I looked it up to be sure.
Charges, you also have a right to have an attorney appointed. You wish to have an attorney, sir?
Yes.
I believe that's Mr. Phelan, an officer of public defense, so he'll be appointed to handle your matter. I've been provided with a proposed no contact order regarding a Heather Briggs. Ms. Michael, any objection to that?
No objection, Your Honor.
All right. So, Mr. Martinez, I'm going to enter an order that will prohibit you from any contact whatsoever
It's sort
with
of
Ms.
fixed in
Briggs.
SA.
You'll get a copy of that after court. Ms. Knowles.
Thank you, Your Honor. He does not have any Washington history. However, he does have convictions in Oregon and Utah, including assault, domestic violence, statutory rape from 2019, and retail theft. The state is extremely concerned for the safety of the community, especially the alleged victim in this matter, based on the facts in the probable cause statement. Additionally, with his history, including that statutory rape conviction, we're requesting bail amount of $100,000 and, if released, conditions of release to include reporting to offender services.
Ms.
Thank you, Your Honor. I'm not showing that he had any Superior Court cases, though the statutory is new to me, Your Honor. Miss.
I think the attorney top right. I think that both of the attorneys here are excellent, and she's like, "Woo!" She doesn't come right out with it, but that she's like, "I didn't know about that statutory our case." that's hurting the argument I was about to make.
Mr. Martinez did indicate that he currently has 2 jobs, McDonald's and Taco Bell. While there's no objection to the no contact order, we also would not object to conditions of release. Mr. Martinez is asking that he be released on his personal recognizance. We do understand that these are serious allegations, but I am not showing anything in Mr. Martinez's history that would indicate that he would not appear for future court hearings. He did ensure me that he would maintain contact with his attorney. We are asking that he be released on his personal recognizance.
Give me just a second here. All right. So I am obviously quite concerned about the nature of the allegations. They're pretty significant. The no contact order, at least in theory, protects the victim, alleged victim. I am going to, as part of the order pending trial, I am going to require that he meet with his attorney prior to arraignment, discuss his case, go over the blue sheet. They're going to give you a document over there, sir, that you can go over with your attorney that talks about how your case will progress. I'm going to require as a condition release that you attend court as ordered and report to offender services should you bond out. At this time, I'm going to adopt state's recommendation. I think this is a pretty concerning case, so I'll set it at 100,000. That could be a reviewed arraignment if you choose. So arraignment will be on the 2nd of March.
I was impressed. He does it so quickly you almost don't notice. But he adopts the recommendation, $100,000. I think it's appropriate under the circumstances.
At 9 a.m.
Court is calling 2022 CR 5313A, State of Texas versus Gage Lee Waller. Can I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense?
Jacqueline Lamerson for Mr. Waller.
Are you Mr. Waller?
Yes, ma'am.
I like your shirt.
Thank you.
I mean, it's been a long time since I've seen, yeah, there you go. Well, I mean, it's a good thing you're not charged with that. Okay. All right.
I mean, it'd be in poor taste if you had just been shooting stuff up, you know. But since that's that's cute.
You know, there are no old-fashioned cartoons anymore. Although those cartoons were very violent, but we didn't see it as such.
They don't even play Tom and Jerry no more.
Oh, wow.
Yeah.
So is this Mr. Baird? You're Mr. Baird?
Yes, Your Honor.
Okay, I might be too soft because I'm sure this guy did whatever he's accused of and was annoying and needed to be arrested and everything else. But he charms me. The defendant gets me here. He's just so simple and not fighting it that I don't know. Tell me if I'm wrong. Tell me if I'm too soft.
So the forms don't have electronic signatures. I guess I'd ask corrections. Is there going to be a paper form mailed or something? Or faxed, I mean?
We have fax available. If you send it through, we can get it signed, presented.
Sir, do I have to wear this before the judge? The mask over like some kind of a bandito or something?
I can take that off.
Oh, thank you. God bless you. Thank you. I'm looking at the judge that makes me feel kind of like, gee whiz, you know? I want him to see my face, you know? Jeez.
Okay, so hang on there, Mr. Baird. Just
Yes, Your Honor.
let me figure out what's happening here today.
First of all, I agree with him. It's pointless to have this mask on at this point. You are in a hearing. You do want to communicate with the judge. You do want him to see your face. It makes me think that you're being honest. And he drops the phrase, gee whiz, with a straight face. I mean, come on.
Yes, Your Honor.
So Mr. DePeyster, did you consult with him about, he's here on 2 criminal trespass charges. What's your understanding of what was going to happen today?
Certainly, Your Honor. So I raised 1077 about 14 days ago. That email came back yesterday, finding that we are able to proceed. I have no objection to that. With that development in the case posture, Mr. Baird and I reviewed the 2 plea forms in Laserfish right now, gone over those in their entirety, and we're asking the court to accept change of pleas in both cases.
Is that your understanding, Mr. Baird?
Yes, Your Honor, it is to the letter.
Okay, hang on just a minute.
Yes, sir.
Just can't wait to plead guilty.
So I went ahead and moved the unsigned forms. Objection rule.
Okay. So, Mr. Baird, I have 2 statements of defendants on plea of guilty, which tells me you're pleading guilty. One was alleged to have occurred on February 5th, 2023. One was alleged to have occurred on February 6th, 2023. And you intend to plead guilty to both of them. Is that correct?
Yes, Your Honor, I do.
And do you understand when you plead guilty, you give up all the rights contained in paragraph 5 of your plea form?
Yes, Your Honor, I do.
The maximum you can receive on each one of these is 90 days in jail and a $1,000 fine. Do you understand that?
Yes, Your Honor, I do.
You've been up there for 15 days. Is that correct, Mr. DePeister?
That's correct, Your Honor. On the first count, he was booked, then released. So he did a day. And on the second count, he's been in for 14 days.
Got it. And so basically the city is asking for 90 days in jail, give you credit for whatever time you have there, and then suspend the remainder. So you'll be getting out later today. Do you understand that?
Yes, sir. Yes, sir, I do, Your Honor.
And the conditions aren't very difficult. You have no criminal law violations and you got to stay away from that 7-Eleven. Do you understand that?
Yes, sir, that is priority. That's priority one. I will never, ever go near there again. Ever.
Oh, man, I got to get together. All right. And do you understand I'm not required to do that? It's a recommendation made by the city, agreed to by you and your attorney. I don't have to do that. At this point, I don't see any reason why I wouldn't.
No, sir, you don't. You're not bound by that. No, sir.
All right. And anybody make any threats or promises other than what's contained in that recommendation to get you to plead guilty?
No, sir. No, sir. No.
And you're making the plea freely and voluntarily?
Yes, sir, I am, Your Honor. Yes, sir.
Give me just a minute.
Yes, sir.
Paragraph 11 in the case ending in 765 says, on or about February 6, 2023 in Lacey, you unlawfully entered the grounds of 7-Eleven knowing that you've been previously trespassed from that location. Is that true?
Yes, sir, it is, Your Honor.
And your signature is blank, but you
also, it's the complete acceptance. I'm sure he was a complete jerk at the time. I'm sure he needed to be arrested, but he is not fighting this. He is not ducking responsibility. He's not shim-shamming. He's just like, I did it. It's wrong. I'll stop. I don't know if that's true, but you can ask for nothing more.
Viewed this with Mr. DePeister, and you agree that's what you did, and you understand this plea form in an effort to plead guilty.
Absolutely, Your Honor. I do understand that. That's what I did.
And on the case ending in 530, paragraph 11 reads, on or about February 5th, 2023, in Lacey, you unlawfully entered the grounds of the 7-Eleven knowing you've been previously trespassed from that location. So kind of the same factual scenario on two different days. Is that accurate?
Yes, sir, it is.
And you agree both those things happened?
Absolutely, Your Honor.
And you reviewed all these forms with Mr. DePeister? Yeah.
Yes, sir, I have, Your Honor.
Do you have any questions at all about what's happening here today?
No, sir, I don't. None whatsoever.
I will accept your pleas on both counts.
Thank you, Your Honor.
Enter finding the pleas were made knowingly and voluntarily.
Thank you.
Enter findings of guilty to criminal trespass in the second degree.
Thank you, Your Honor.
And I'll hear from the city on sentencing. After that, I'll hear from Mr. DePeister. And then, Mr. Baird, I'll give you the opportunity to speak if you wish to take advantage of that. Mr. Sharp?
Thank you, honestly. Would ask the court adopt the recommendation. It's agreed between the parties.
Mr. DePeister?
Thank you, Your Honor. Mr. Baird comes to court to take responsibility for his missteps on going to that 7-Eleven when he wasn't wanted and then returning after he was released from jail. I had some concerns about his ability to proceed. Western disagreed with me, but they did note some history of difficulties that Mr. Baird has gone through throughout his life. He realizes that he is not ever to go back to that 7-Eleven. If he is released, he plans on taking care of the outstanding issues in Olympia and in Kitsap, and he looks forward to getting out to see his 5 kids and his 7 grandkids.
Yes, sir.
So, Your Honor, we're asking the court to follow the agreed recommendation.
Mr. Baird, anything you'd like to say?
Well, real in short, I thank my defense for my counsel. In 12 days, for what it's worth, Your Honor, it's been over 37 years since I've seen a jail cell, and it has nothing to do with that. I'm just grateful that, For what it might sound kind of great, but I am grateful this happened because I got aligned. I needed some alignment that my wife of 23 years couldn't give me, all my kids, grandkids couldn't give me, all my workers and my business couldn't give me, and I got it. I'm so grateful that it happened. And Your Honor, I'm guilty as charged. I will never, ever go anywhere near there again. And I'm going to fulfill, one step at a time, fulfill all of that things that I should have done. But I'm not a woulda, coulda, kind of guy. We get it done.
All right, Mr. Baird, give me just a second here.
Thank you for incarcerating me. I needed it.
Yeah, it looks like you have some warrants you need to take care of out of Bremerton Municipal. Are you aware of
Yes,
those?
sir. Yes, I am, and I'm going to get them done. Take care of them.
And Olympia Municipal also.
Yes, sir. I'm going to get them done. I had
All right, on both of these cases, I'll impose 90 days jail. On the case ending in 5/30, I'll suspend 75, give you credit for 15 served. On the case ending in 7/65, I'll suspend 76, give you credit for 14 days served. You'll be released on both of these later today. Given the nature of the charges and the amount of time you spent in jail, I'm not going to impose any financial obligations at all. And
yeah, he is.
Do you have a place to go when you get out?
Yes, sir, I do, Your Honor.
Okay, good. Good.
Can I say one more thing, Your Honor?
Yes.
God bless you, Your Honor, and have a good day. Okay? That's all.
Thank you, and the same to you, sir. You'll get released here later today.
Thank you, sir.
Yep. Good luck going forward.
Oh, I'm going to do it. Going to do it.
All right. You may go.
Thank you, sir.
And Your Honor, I move to withdraw on both those cases.
You can be removed on both these.
Thank you, Your Honor. Best of luck, Mr. Baird.
Thank you.
And you're free to go, Mr. Baird. Good luck going forward,
Thank
sir.
you. You guys have a wonderful day, because, yep, gonna be all right now.
And then Mr. Gomez, it's now 2:12.
They had other calls, but both the attorney and judge sort of acknowledged it very briefly with each other that was cute. I don't know. So there we go. I leave you on a high note. I would not play with you. I told you I scrounged and I found something worth watching. And that guy kind of made my day. Thanking the judge for incarcerating him. But not only that, it struck me as sincere. He's like, whatever, I'm a mess. You know, I needed some boundaries. Someone put me in the clink for a few days. It's pretty much exactly what I needed. All right. You know, I think there's a chance that he's not kidding. I mean, he's probably homeless, so he'll probably run into other issues, but I don't know. That was kind of fun. I left it to the end on purpose so we could leave on a high note. Thank you all for coming out. I'll see you soon.